Welcome if you're just joining us. See more people coming through the waiting room process now. We'll be getting started very shortly. Hope you're all well and you're enjoying the last of the nice weather before thunderstorms predicted for later this week.
I'm glad you've got your usual weather forecast in there, Sean.
Definitely.
Where would we be without an event with your weather forecast?
I know, not Michael Fish.
I hope not.
Well, yeah. Definitely not going to be thunderstorms.
I really hope they're wrong.
Yeah. Okay, it's 3 minutes past, so I'm conscious of everyone's time, so let's make a start. So, good morning, everybody, and thank you for joining today's session. I'm Sean Gibb, I'm the Events and Marketing Manager at Pro Manchester, and I'm delighted to welcome you to Business Contracts, How to Negotiate and Enforce Your Contracts, hosted by Ward Hadaway. Following today's session, I'll send out a post-event email which will contain any post-event collateral, any links to where you can find out more about today's session and about other Pro Manchester events. And it'll also include our feedback form. If you could please take just a couple of minutes to complete this. It is a really short survey, but it really does help us to provide consistently great content and to come up with some good ideas for future webinars. So please do just take a minute to do that. Just a couple of points of housekeeping. Please be aware that this webinar is being recorded. Feel free to use the chat function to ask any questions, make any comments, observations, and we'll address those at the end. And please keep your microphones on mute for the time being, just so we can ensure the best audio quality. So without further ado, I will hand you over to Nichola Evans, Partner, Commercial Litigation at Ward Hadaway.
Thank you, Sean, and thank you, Sean, as always, for your assistance on putting on one of these events. Welcome everyone to this session, which is brought to you by Ward Hadaway. We are, for those of you who don't know, a full-service law firm based in 3 locations: Newcastle, Leeds, and of course, wonderful Manchester. Now, I'm quite heavily involved with Pro Manchester, and we get feedback from our members to see what sort of events that people want us to run. And what we have found is that members have come back to us and said, because the government has been changing the law quite frequently, and obviously that there have been contractual issues between B2B business contracts, what people wanted to know was what they can and should be doing in order to protect themselves, both in the formation of contracts and also afterwards if they do have to bring proceedings or think about enforcement action against other businesses. Now, today I'm joined by my colleagues, Rebecca Whisker, who is in our commercial team, and Vicky Alexander, who manages our debt team, and they will chat through the issues. So Rebecca will look at how you should negotiate key terms in business contracts and what you should do at the outset in order to protect yourself. Vicky will then look at how you can enforce your rights, drilling down into the COVID restrictions that currently exist. And then she's very kindly got her crystal ball out so that we can look at what the future might hold in that respect. Now, we also have the chat function today. So if you have any burning questions as we go along, please do drop them into the chat function. We will pick those questions up at the end of the session, and we have allowed time at the end of this session so that we can have a short Q&A so that we can address any queries that you might have. So I am now going to hand over to Rebecca. Thank you, Rebecca.
Thank you. Okay, so I'll just share some slides. Yeah. Okay, can everyone see that okay?
Rebecca, that's just on preview.
Oh, okay, thanks, Vicky. Still on preview?
It is, I'm afraid. I'm not sure why that's happening.
Oh, jeez. Is that visible?
I'm
No,
afraid
I mean,
it's still doing it, but we can see it, Rebecca. Your main slide is it just gives you a view.
Okay.
If you need to proceed, I think everyone can view.
All right, great. Thanks, Vicky. Okay, so as Nichola said, the main purpose of my section is just to give a bit of an overview on the key areas within business contracts that are often most keenly negotiated, and some pointers about how those negotiations can be approached. So before going into those detailed provisions, I kind of just wanted to make a few points about the practical benefits of getting them right in the first place. So aside from the first kind of obvious point about avoiding disputes, clearly, if there's disagreement on terms of the contract, if you can consult it and there's little room for ambiguity or interpretation, then obviously any disputes are much easier to resolve. And another kind of sort of less straightforward point, I guess, is that having really well drafted contractual standard terms can really set you apart from competition, because if you've got terms that are out of date or really off-putting, then that can kind of deter potential customers and prevent you from winning business potentially. And thirdly, if ever you had any plans to sell the business, any buyer will want to review the terms on which you do business. And again, if those contracts contain any onerous or unusual terms, then that can again be something that is questioned. So here I've just got a little summary of some of the main types of contracts that a lot of businesses will enter into, and obviously there's further examples, but these are really just the kind of main ones, and the most fundamental being the sale of goods and supply of services agreements at the top. The others follow the same sorts of principles, kind of just slightly more complex, and frameworks, for example, where you have a long-standing relationship under which a customer can call off services for an individual project. And the key point about this really is just being aware of what it is that is being negotiated, because it might require a different approach. If you've got a framework agreement that's going to be in place for a number of years, then maybe that will merit more attention and resource than a one-off sale of goods agreement. At the bottom four there are just very specific types of IT agreement, which again follow the same sorts of principles, but will contain very specific provisions tailored towards the technical nature of the products being sold. And they can require a lot of input from people within the business, aside from kind of legal people. So technical personnel might have a role in negotiating the more technical aspects of those documents. So moving on then to the key terms that are often most important and keenly negotiated. The parties one seems really obvious, and it's a really obvious statement to say that it's important to check the parties to the contract are correct. But if you're dealing with a customer or supplier that's part of a wider group structure, this can sometimes be tricky. So always undertake due diligence on the financial strength of the party that you're going into business with. And if, for example, you entered into an agreement with the wrong group company that doesn't actually hold any assets, that can cause problems from an enforcement perspective. But also, if you're acting as a supplier, it's really important to clarify what you actually mean by the customer, particularly in the IT context, for example, because if, for example, you're licensing software, then if a customer one company within the group licensing software is very different to that software being licensed across the entire group. And getting these things negotiated at the outset will be really important, because it might well feed into the pricing and the commercial aspects of the contract that are being agreed at that point. So looking at goods then specifically for a minute, having the goods kind of precisely and clearly defined in a contract is, again, something that seems very straightforward, but is actually often overlooked. And it can be done by reference to a detailed specification. So fundamentally, it's clear what's actually being bought and sold under the contract. The contract should also set out some very specific standards that the goods should meet. And this is something that is often really, really keenly negotiated between the parties, because a supplier will want to limit this down as far as possible, usually committing to no more than the statutory minimum of the goods being of satisfactory quality and reasonably fit for purpose. Whereas the customer would want to widen this to something like it being fit for purpose, any purpose that it makes known to the supplier. So the significance of actually negotiating these warranties or promises in the contract is that, you know, if the supplier breaches any of these warranties, the customer will be entitled to bring a claim against them for damages. So it makes sense that the supplier will want to do all it can to kind of limit these down as much as it possibly can, to sort of reduce the potential liability under those warranties. I've mentioned acceptance there because you know, it's a good idea if you're the customer to build in some sort of safeguards to allow yourself to actually inspect goods, make sure that you're happy with them. And again, something that the supplier might resist, but it's a way of preempting any potential difficulties, you know, further down the line. Moving on to services then, when services are being bought and sold under the contract, the principles are very, very similar, but some slight differences just kind of resulting from the different nature of services as compared with goods. Again, as with goods, you need a clear service specification that sets out what services the supplier will provide. But also bearing in mind that even though it is a services contract, there may well be some deliverables that are created as part of the services, like documents or software. So a legal point arising from that is thinking about who will actually own the IP or intellectual property in those deliverables and ensuring it's documented correctly. And again, warranties included in the contract around the standard of performance that's required. And again, something that's very, very keenly negotiated. So the supplier will want this to be as narrow as possible, and the customer will want it to be more onerous. But in services, this is often done by way of SLAs, so service level agreements or KPIs. And often they're included. This is where I kind of mentioned about the technical personnel, perhaps within the business, getting involved in the negotiation of those documents. And I think something worth bearing in mind there is that that's where the real detail will be contained in terms of the actual performance of the services. And often it'll be included in a separate schedule to the agreement, but still has binding contractual effect. So it's worth kind of dedicating some time and resource to actually getting those documents right as well, and not just focusing on the kind of what are seen as the main provisions of the contract. Sometimes we'll see wording in relation to contractual obligations stating that performance, well, time is of the essence in relation to performance of that obligation. And it's something that can kind of creep in and appear to be quite a harmless provision, but essentially means that if the supplier, for example, doesn't perform the service at that time, a breach of it will be something that gives a right to terminate for the buyer, not just a right to claim damages. So clearly, it's kind of an example of where you know, language can appear sort of quite harmless in the contract, but can give rise to some unintended consequences potentially. So yeah, moving on to payment terms, which are obviously something that are of a massive kind of practical concern when you're entering into a contract. And at a very basic level, both parties will want to set a time period, so a number of days in which payment will be made under the contract. And I think the main thing to bear in mind here is to ensure that this actually ties in with your business's cash flow arrangements. You know, for example, if you agree that your customers can have 28 days to pay their invoices to you, it wouldn't make sense for you to then agree to pay your own suppliers within 14 days, because overall you then potentially have a cash flow difficulty. Obviously, in the kind of COVID environment, a lot of suppliers and customers, you know, sort of seeking to amend those payment terms going forward so that it gives them a little bit more breathing space. But again, tied with payment, it's a good idea to set out some clear remedies in the event of non-payment. So agreeing the rate of interest that will apply to late payment, failing which a statutory rate will apply, including provisions like whether the supplier can suspend the services in the event of non-payment, or whether they can even terminate the entire agreement in the event of non-payment. So these types of provisions can actually really help to drive behaviour and compliance with payment terms. So liability is obviously, again, crucial, and it goes without saying it's probably one of the most important clauses, the purpose being to set out and potentially limit the parties' kind of liability and exposure to each other in the event that things go wrong. Excluding liabilities is obviously really, really common, but it's important when you're negotiating these provisions to remember that there is a statutory framework that sits behind what is agreed between the parties, and there are certain losses and liabilities that can't be excluded or limited by law, such as death or personal injury caused by negligence. But subject to that statutory framework, it's common for parties to agree monetary caps on their liability where that's possible to do so. But sometimes it can be difficult during negotiations to kind of come up with an appropriate cap for that. Commonly, people will use contract value, or they might cap it at the total fees that are paid under the contract in the past year, for example. But I think the point to bear in mind with that approach is that there are certain losses that can arise which you know, they don't really bear any relation to the contract value, such as breaches of data protection legislation or breaches of IP provisions, breaches of confidentiality. So when you're deciding whether to accept a cap that the other side has put on their liability, it's worth thinking what the overall exposure could be if that risk actually materialised. And so for that reason, it's common to sometimes exclude certain areas from the scope of a liability cap, such as data protection, IP and confidentiality. And another factor which are really important to consider in that regard will be sort of what level of insurance cover you can actually obtain. Because if your insurance is much higher, then again you might be more minded to accept a higher cap on liability. Indemnities are worth a mention because they're something that can be really, really valuable if they're agreed to. Like, for obvious reasons, parties often resist giving an indemnity because essentially it's a statement in the contract that one party will indemnify the other in respect of all losses arising from a certain breach. So depending on the drafting, this can be really valuable because it could actually potentially allow that level of recovery. Looking at IP then, IP is really, really vital, particularly in technology contracts and IT, where that's often the most important and valuable asset that's at stake. So the first question is really whether IP is a concern and what IP is likely to be used or created in the performance of the contract. Obviously, there are lots of different types of IP, whether it be trademarks, designs, copyright and patents. But on a very basic level, it's just important to think about if one of the parties needs to use any IP of the other, then the contract should provide that they have a license to use it for purposes at least of performing contract. and also crucially if any new IP is being created as part of the contract, as I mentioned before. The contract needs to set out and so, I mean, IP provisions can become really complex, particularly if you've got both sides feeding in and contributing some IP. But the fundamental point is really that, you know, the ownership and usage and licensing of worst case scenarios is that you don't give away some IP that you thought you owned. And again, modifications, improvements and enhancements throughout the life cycle of the contract. New IP may well be being created all the time. And so imposing or introducing some provisions at the outset that deal with that and deal with ownership and licensing is also really important. I'll just mention data protection briefly. It will apply, you know, in a lot of cases. And I think, you know, whenever entering into a contract, it's crucial to ask whether there will be any personal data that's being processed, because if there is, which, you know, largely there will be some element of personal data, then, you know, data protection legislation will apply. If one party is processing personal data on behalf of the other, then the contract will have to comply with UK GDPR and all of the potential consequences that flow from that. There's specific statutory provisions that have to go in the contract, but there is some scope to negotiate, particularly in terms of timescales. So if, for example, there's an ICO deadline that you would need to meet, it's ensuring that you build in enough time to actually be able to comply with that if you're relying on the other side to provide you with information. Again, mentioning indemnities because, you know, parties will often seek data protection indemnities where it's a particularly high risk in the context of the overall contract, just to ensure that the massive liabilities that can arise can be recovered. Termination then, and this is one of the kind of important areas, I guess, from a COVID perspective. Getting out of the contract is obviously really important that you cover kind of how that can be brought about. Termination for cause and termination for convenience are obviously sort of different vehicles. Termination for convenience is just a right that you might include if you're the party to terminate the contract at will. So that's just a matter for negotiation, and obviously give consideration as to whether that would cause you any hardship. You know, if you agree that the other side can just terminate at short notice. Termination for cause is much more common. You know, most contracts will provide that you can terminate in the event that the other party commits a material breach of the contract. Change of control provisions are also really common. So if the party that you are contracting with is bought out by somebody else, such as that the control of that entity has changed, you may want a right to actually be able to terminate in those circumstances if it's not a business that you want to be in a relationship with. So insolvency is you know, really highly relevant at the moment. And previously you'd see like quite extensive provisions in most contracts stating that a supplier can terminate in the event of, you know, a long list of different potential insolvency proceedings occurring in relation to a customer. But due to the legislation that I've mentioned there, Corporate Insolvency and Governance Act, that essentially a statutory override was introduced that made those provisions unenforceable. So it's difficult. I mean, keeping those provisions in is probably advisable because there are some suppliers who can still rely on them. And also it might be that the position changes in the future, but it does also mean that you kind of have to consider potential other triggers for termination that you might want to apply, and making sure that, you know, in light of the fact that those original triggers will no longer be enforceable, are there any other situations that you might want to build into the contract to make it, you know, so that you can terminate when you need to? And last one, I've just put some key tips. So the first one is, does the contract do the job? So often we can kind of reuse, like people reuse contracts, and so it's really dangerous, I think, to use a contract or some standard terms that have been prepared for one purpose, but that might not meet the needs that you need in the current transaction. Really, the purpose of the contract is just to reflect what's actually happening in practice. And so if you kind of reuse something that's been drafted for something else, it can, you know, it's not going to do what it's meant to do. Record keeping and audit trails, particularly signed contracts. So often, and a lot of time and effort is put in, money and resources are put into negotiating a contract. But kind of sometimes then if things go wrong further down the line, it can be difficult to get a hold of the actual contract that was agreed. Maybe it wasn't signed. So it's just kind of easy things that can be done to improve kind of the resolution of minor disputes. Timing of negotiation. So aside from the kind of legal things that you can do and try and seek to get into the contract, giving enough time to actually have those negotiations so that you're not under the pressure of the deadline on the current terms being automatically renewed or things becoming urgent will help to help to mitigate the sort of urgency and mean that you might get a better outcome. And just repeating the point I made before about schedules being part of the contract, just like the main contract terms, they deserve as much time and attention in negotiating them as everything else. So I think that's all I was going to mention. I hope that's been helpful, and I'll hand over to Vicky.
Thanks very much, Rebecca. That was really informative. And as a debt recovery specialist myself, I'm always advising people to get their contracts right and the importance of that. So that was really helpful and set in context what I'm just about to discuss. I'm just sharing my screen. I wonder, Rebecca or Nichola, could you just let me know if that's visible?
Yes, that's visible.
That's great. Thank you very much. So I was asked today to talk to you all about the enforcement of business contracts. And as a debt recovery specialist, my area is to look at when businesses in particular don't pay other businesses debts that are due and payable, and to look at what options and remedies are available to you. And I thought it was very important today to have a look, because it's been such a change in landscape because of COVID. It's had a dramatic impact. So what I wanted to do was just have a little reminder about the remedies and options that are available to you when there's a default upon payment terms. Then have a look to see what difference COVID's made, what restrictions have been beginning. I'm going to use my my magic ball to look at the future and just see and just have a little bit of discussion around what we anticipate. Nobody knows for sure, but what do we see happening in the future? So just starting off, just talking about the available options to you before. One of the most frequently used tools for debt recovery is winding up. So taking steps to issue a petition to put a company into liquidation. Now, often this is considered quite a draconian measure and quite aggressive, but actually it is a very effective technique. £50, unlike the higher bankruptcy threshold. So it really helps in terms of if you have a debt as a business owed by a limited company or a partnership, you can issue a petition. One important fact to always remember is that with winding up petitions in any type of insolvency action, the debt must be undisputed. If the debtor who you've had that relationship with has raised a dispute or any sort of issue that needs to be resolved, it's not suitable for this route. Now, when I said that it's quite a draconian measure, I think it's worth bearing in mind that very rarely will a company actually be placed into liquidation as a result of this being used as a debt recovery technique. It is a tactic. And what you find is when you commence a winding up petition, it will be served by a process server, but the key part of the process is when you advertise in the London Gazette. And when you take that step as a creditor to advertise, banks are notified, and what happens is the debtor's bank accounts are frozen. Now you can imagine that that will have a massive impact upon the company. So generally speaking, once the petition has been served or before the petition is advertised, a company will do everything it can to settle the debt. And they will also pay your costs as well in doing so to get rid of that petition. So whilst it can be quite a robust procedure, very effective, and certainly something that is to be a go-to technique for the recovery of debts. One of the other options, and it's quite commonly used, are county court claims. With the view to getting a county court judgment. And this is a technique that you can use against any type of legal entity. So it could be a sole trader, a limited company, a partnership. You can bring a county court claim. It's a much longer process than winding up. And unfortunately, as some of you will know from experience, the court fees can be extremely high. The higher value of the debt, the higher the court fee. Now that is recoverable as a disbursement if you're successful in your case, but it can mean an initial outlay that's quite considerable. That said, it is another effective technique because often companies don't want to have a county court trade. They want to keep a clean sheet. So they will take steps to avoid that. And the idea is that we're looking for engagement. We don't really want to get to judgment, but if necessary, we will enter judgment. Court judgment doesn't mean you get payment. It's an order that says that the debtor owes money. Sometimes you have to take additional enforcement steps. So you need to be aware that that's the first hurdle that you cross in getting the judgment, but there may be steps that follow. My next point is about high court enforcement, and generally speaking, my clients who have debts as a business will use this as an enforcement technique when a judgment isn't paid and when they haven't gone down the insolvency route. We use high court enforcement officers, which are basically private bailiffs, because court bailiffs are salaried, they don't have much incentive, and they will turn up at a property or a commercial premise and they won't do a great deal to recover the debt. So we get out the private guys who can enforce on any debt over £600, and they can seize goods. There are limitations and it's beyond the scope assets that aren't subject to credit and that belong to the debtor and must be owned by them with a view to auctioning those goods. In my career, over 17, 18 years, I think I've had 1 or 2 auctions. Usually companies will engage and they will pay the debt or give proposals for payment of the debt. So it can be an effective technique, although often you're reliant upon engagement. The final point that I've put on here, which is often not considered, and particularly as parties' positions are entrenched, is to look at negotiations. We have a duty as parties. So as a business who might bring a claim or a petition, we have a duty to attempt to resolve the position without entering into court proceedings. It can reduce costs and be an effective commercial solution. I always say to clients, there's no point in sort of lining a solicitor's pocket if you can have a commercial discussion and you can reach a resolution. Always try to do that, particularly if there are disputes raised. One last thing just to mention before we go on to where we are with COVID is whether you can take any action against directors. Often I find that businesses forget that you can request a personal guarantee. You can have a cross-company guarantee as well when you're dealing with large organisations. They're a really, really valuable tool, particularly if the company goes under. If the company goes under and you have this personal guarantee, whether it's limited or not, you can take court action or apply to bankrupt that director, and it gives you another route of recovery. So I would say always consider, is it worth doing it, particularly if you've carried out early checks and you're concerned about the financial status of a company. Protect yourself, use a guarantee. So just moving on to some of the restrictions that have come into place, and as I mentioned before, there's been a huge impact by COVID. It has really, really affected the debt recovery market, and we've had to be very creative and look for other solutions to recover debts. Rebecca mentioned before about the Corporate Insolvency and Governance Act. I've mentioned that first because that has placed heavy restrictions on winding up, which I've just talked to you about and explained is really a key tactic for businesses. Contrary to popular belief, it doesn't ban winding up petitions, but it heavily restricts them. It means that you can't present a winding up petition to the court unless you can demonstrate that COVID has not had a financial effect upon your business, upon the debtor's business, and that the debtor would have been in financial difficulties even if COVID hadn't occurred. Now, I'll be honest, most businesses just haven't issued winding up petitions because that's quite a high threshold to cross. It's not to say that you can't do it. And if you have a persistent defaulter or someone with a lengthy history of default, it's still possible, but you need evidence. You can look at Companies House and get accounts to show that the company has been in difficulty, but you're going against a presumption really that the court will hold that COVID will have had a financial impact. They will be really starting out with that position. I've mentioned as well about the impact upon courts and service delivery. The courts, we all know, are very slow anyway. They're not, because they're a public driven entity, they're not the greatest at turning work around and timescales anyway, but COVID has really significantly impacted that on that. We're seeing much longer processing times. Some applications aren't even being listed for hearings. And just to give you an example, orders for sale of properties just haven't been heard. They've been stayed, and of course, there are more wider restrictions in that regard. And also your ability to get the debtor to court to examine them under oath. That's not allowed at the moment because there can't be face-to-face hearings. And also there's been a move to remote hearings, which I think is actually a really positive thing. And I think it's really working well. And I think it's probably here to stay, but it's definitely impacted. It hasn't stopped debts from being pursued, but it has slowed that process down. So High Court enforcement, the good news is that most of the impact was on residential properties, attendance at residential properties. So High Court enforcement officers couldn't go out to any properties initially. There were no personal attendances allowed, but once we got past that initial, I think it was 3 or 4 month period, I think it was about August time, August 2020, the High Court enforcement officers could go back out and they could attend those commercial premises. The difficulty for creditors, for you as a business, is that often businesses are no longer trading, or they're not trading from the registered office, and it's really difficult to get that engagement. So there are more difficulties, but we're certainly finding, and I'll touch on this in a little while, We're certainly seeing more results, more recoveries now, and the High Court Enforcement Officer are back to their wider powers now that they had pre-COVID. I've also just mentioned about protection for tenants, which goes beyond the scope of what I'm discussing today, but obviously commercial rent arrears recoveries, there's a restriction on that till the 30th of June. At the moment, unless there is a significant level of commercial rent outstanding. No forfeiture of leases till the 30th of June as well. And generally just a great deal of protection around tenants at the moment. Government support. I found it really difficult as a debt recovery practitioner to understand the government's approach, because individuals and man on the street, there weren't really a great deal of restrictions on debt recovery. You could still bankrupt someone, you could still take them to court, and there wasn't a great deal of restriction. But there, in terms of businesses, there was a great deal of support. There was the deferral of VAT, significant grants and loans really giving a great deal of support, business rate reliefs as well, and also quite significantly the furlough scheme. So there was a lot to bolster businesses and keep them going and give them that support. So I think it's just worthwhile, although that's not a restriction, just in the general context of realizing what impact COVID had. So just to the final part really, as to what do I think the future is, and I've put a bright blue sky there. I am quite positive, and a lot of what I've covered there seems quite doom and gloom, but we are seeing a recovery. It's most certainly a long road, and there's a long way to go, but we're seeing restrictions starting to be lifted. And what I think is a really positive indicator is that for individuals, there are now evictions going ahead. It may not be positive for individuals themselves, but it shows that the government are lifting restrictions. Repossessions are going ahead. The government appear to be appreciating that these restrictions can't continue indefinitely. They have to ease. They can't support businesses indefinitely. And I'm really hoping that, together with the restrictions being lifted for High Court enforcement officers around residential visits, will mean that the Corporate Insolvency Governance Act restrictions on winding up petitions, which are due to be reviewed at the end of this month, will be lifted. What we don't know is whether there will be some form of restrictions or limitations moving forward. Will the government use this as an opportunity to tighten what sort of recoveries can be made against businesses? There have been no indications at this stage, but for anyone who has followed this area, you'll be aware that it's very much the 11th hour. It will probably be on the 28th or the 29th of June when the review takes place. So we just don't know. But we need to watch that space, and we're feeling positive in the debt market that even if there is an extension, that it would be a short extension and that recovery is on its way. What else are we seeing in the future? We think there's likely to be a general increase in insolvencies. A lot of your debtors have had the benefit of government support, and it's likely that when that safety net is removed, that some of these companies are going to hit difficulties. So we need to just be prepared in terms of who you're trading with initially, the financial status of that company, but also given that consideration before you take debt recovery action, making sure that your resources and your legal spend is spent well. We also think that there's likely to be more high-profile insolvencies. I think that's a continuing thing to come. We've seen a lot in the retail sector in particular. COVID has really changed society and businesses and how we operate, and that's likely to continue. I've mentioned there about the government support ending. Furlough is well as another one just to consider. I think it's starting to be phased out from July with an end in September. That's undoubtedly going to be a factor in people's ability to pay debts, and also on businesses and having that level of support to retain their workers. So do we think there'll be a massive arrears of debt? What do we think we're facing? Nobody knows for certain, but when I've spoken to a lot of my contacts and clients, what they have said is their defaulting books, their non-performing customers have actually performed a lot better than they expected. They really did put measures in place and make forecasts that it was going to be quite grim, but actually people have engaged. There's been a lot of engagement. There's been a lot of arrangements, and things aren't as gloomy as they expected. So yes, there will be some arrears of debt and there will be action to take, but actually the market generally has performed better than we expected. Just a couple of other points just to look out for. The Inland Revenue, HMRC, I don't know how many of you know, but about 20 years ago, the law was changed so that the revenue had no sort of priority as a creditor, meaning that they ranked equally with other creditors should a company go into insolvency. That actually changed from December 2020, and now the Inland Revenue is a priority creditor. They'll come across ahead of floating charge holders and also unsecured creditors, which many of you may fall into that category. So it means that if you have a debtor who goes into insolvency, potentially there may be less in the pot to go around, and or you may be further down the queue. It also means, and I'm sure most of you will know this already, the Revenue are particularly keen on debt recovery. Obviously, they have duties and obligations. We expect them to be even more proactive in the debt collection market, which means it's really important as creditors, as businesses, that you take early action. Institutions like the Revenue won't wait. We all know that your best chance of getting repaid a debt is to be at the front of the queue. Don't delay, take action when you can. Just a couple of other things to watch out for. Breathing space, which is effectively a moratorium, a stay on legal action while somebody seeks financial debt advice, has been brought in already for individuals in May, which allows a 60-day breathing period for individuals. There is also a consultation ongoing for businesses proposing a 28-day stay where you wouldn't be able to take any legal action at all. I would say just watch that space. There's a lot of opposition to it, but it's something which potentially could come in and certainly has come in for individuals. The last point Rebecca's already referred to within her section, just in terms of your contract, you can't always, there have been changes brought in, which has now stopped you from terminating a contract based on insolvency, which I know I had quite clients who would rely on that if the payment terms weren't caught. Just beware of that. It may change in the future, but we just don't know. So finally, just a few takeaway points before we open out to our Q&A session. I mentioned there, take early action, be front of the queue. If you don't get to the front of the queue, your debtor will pay the person who's placing the most pressure and who is taking the most robust action. Don't be frightened to be forceful and take a strong approach. As long as you follow pre-action protocols, as long as you follow your own processes and have a good established credit process in place, you will not be criticised for taking a robust approach. When you contract with a party, take up references, research who you are contracting with, do a financial status check. Often I have to support clients to recover debts where really They shouldn't have given out credit in the first place, or potentially shouldn't have contracted with them because really they weren't in a good position. On your application forms or whatever documentation you use, if you get a reference, take it up, see what their position is, look into them, make sure that you minimize your risks of having to use debt recovery action further down the line. As Rebecca alluded to, retain records to support any claim. I often get into debt recovery cases where the contract can't be located, the terms and conditions, or we don't know which version apply. Retain evidence that you've actually provided the other side with a copy of the terms and conditions, and they've seen them and had sight of them, and they therefore formed the contract. Make sure you get your house in order and do that. Finally, as I said at the beginning, consider using guarantees. It's an additional step, and sometimes, yes, it may deter someone from entering into a credit arrangement with you, but it's worth asking why. If they're financially viable and they're in a strong position, they probably won't mind providing that guarantee. So always consider, is that worth doing? Thank you very much for your time. And I'm just going to hand over. Nichola, I don't know if you'd like to just take over from here.
Yeah, I will take over. I've been monitoring the chat box, but we don't have any questions from anybody attending. I don't know if anybody wants to step in at the moment, but while I'm waiting potentially for a volunteer, I suppose one thing I was going to mention is we have this moratorium until the 30th of June. We don't know if it's going to be extended. Now, if I flip it and we look at a company in difficulty here, surely the advice as well is to do your risk management if you're in that position as well, where directors need to have a look at the liabilities, potentially take professional advice, because if those restrictions are lifted on the 30th of June, then potentially those directors could be looking at personal liability. So there is a risk management approach to be taken when potentially these restrictions are lifted in, what, 15 days time? I don't know if either of you want to comment on that.
Yeah, I think that's essential. It's really, I think it's difficult because we don't know when those restrictions will be lifted, but there's a good chance on 30th to make sure you're prepared. As Nichola says, get your house in order, make sure you're prepared for that. It's only a couple of weeks to go.
I do have a question, and it's probably easier to verbalize it than type it in, if that's all right. So something I come across quite often is I will agree a contract with a client, so I'm in professional services, and then we will get a purchase order back from that client, which has on the back of it a standard goods and services conditions of contract. So I've always been told to, last card down wins. And so usually it requires me to go back to them to say, yeah, thanks for your purchase order, but we are working under the terms and the conditions agreed. Would that really stand up in court if we had agreed a contract, and even though we've received a purchase order, would the court look at and say, well, yeah, they've agreed a contract, so actually what was on the back of the purchase order is nonsense anyway?
Shall I take that first of all then, Rebecca, as a commercial litigator?
Sure, yeah.
It still amazes me how many cases we get where there is the battle of the forms, and it is fact and degree in every case. And it's impossible almost to say. I think people have this idea it's the last card on the table that wins, but it's not always the case. And in fact, there was a recent case that demonstrated that that wasn't in fact the case. So it's one of those that I suppose it's the typical lawyer's answer. It depends. And that's probably not what you want to hear from me today, but please pick up with me separately if you wish. Because I know that that is a tricky one where everybody sort of plays their trump card on standard terms and conditions. I don't know, Rebecca, do you want to pick up on that from a contract formation point of view?
I think just to echo what you said, there are things that you can possibly include in the contract to give yourself a better chance. You know, like you've kind of, I think you've already done, to sort of express that your terms will prevail. But as Nichola says, it's not, it'll depend on the drafting and the circumstances as to whether that will work. So I think it's one of those, like you say, Nichola, it's every case on its facts, isn't it? And all the drafting to be considered, really. But
I think what I would say as the litigator, and I'm probably driving business away, the best thing you can try and do in those circumstances is to reach a fudge or a compromise, because the cost of legal proceedings on that with the uncertainty is just so prohibitive. So I'm sure, given that we're recording, this is going on the website, that's a great advertisement, isn't it, for commercial litigation. Avoid us at all costs if you can. We do have Rebecca, I don't know if you want to take that one in the chat function about the integration of personal guarantees.
sorry, I can't quite read that.
So it's basically, how do you integrate a personal guarantee from a director in a contract with a limited company?
Yeah, I mean, you can obviously have those kind of in tandem, because like we've said, kind of doing financial due diligence on the person that you're contracting with is only really as good as the assets that sit behind that entity. I know that personal guarantees, you know, they can provide extra comfort when you're sort of dealing with things in that situation where you think that actually you want to have a personal right of action. But yeah, I'd see it as something separate, really. I don't know if Vicky's got any other thoughts on that.
Absolutely, and I deal with a lot of contested dispute cases in my line of work, and I spend a lot of time dealing with disputed guarantees. And one of the issues that we've experienced in particular is where guarantees have been incorporated into the main contractual documents, and there have been arguments raised that perhaps there wasn't enough prominence given to the guarantee, or potentially that the signatory believed that they were signing contract documentation and they didn't appreciate the implications. Now, these are all points that we can deal with, and we do deal with, a bit like Nichola says, you get into these disputes, and often, unfortunately, they have to go to a long trial. So my advice, subject to Rebecca, who's the specialist here, would be, you know, make sure that the document is given sufficient prominence. My preference from a debt recovery perspective would be to have a separate document. And, you know, I think, you know, I mentioned about the importance of using a personal guarantee, but it's important to get it right. Otherwise, it can open a can of worms. So make sure it's a separate document and seek some advice on it. Make sure it does what it needs to do, because I see a lot of guarantees as well that leave a lot of uncertainty and give rise to a lot of disputes.
That's great, thank you. We don't have any more questions in the chat function, and I'm conscious that we've got 1 minute to go. So is Sean around to take over and finish? And as I say, we will be sending a roundup email which will have all of our contact details on. So if there are any themes that you want to pick up with us going forward, just get in touch.
Thank you so much, Nichola. All that remains for me to say is thank you hugely to our guest speakers today, Rebecca and Vicky, and thank you to Nichola for hosting, and thank you to Ward Hadaway, and thank you to all of you for attending. So thank you very much. We will see you next time, and I'll get that post-event email out to you later this morning. Bye, everyone.
Bye.
Many thanks. Bye, Sean.
Thanks.
Bye-bye.
Bye.